Welcome to the Momkus McCluskey webinar on negotiating contracts with big companies. This is a series of webinars that we put on to help business owners and executives manage their business's legal risks. Today's goal is to give you some ideas about how to negotiate a contract with big companies that have all the negotiating leverage. Of course, you can't change the fact that they have the leverage, but you can take steps to increase your chances of avoiding bad outcomes. So let's get started. We need a little background first. Contracts can be entered into both for goods and services. Initially, we'll focus more on contracts for goods and then apply some examples to services. We'll also probably use some examples from some fairly sophisticated supply chain style contracts so that we can get a good beat on what's actually happening out there. Let's start with talking a little bit about what a supply chain contract might look like. In the typical scenario in a supply chain, one of two things happens. Either you have sales occur by a simple exchange of a purchase order by a buyer and an acknowledgement by the seller, or what you might have is the negotiation of a big, giant master contract, which then governs the placement later of purchase orders or releases. Now, if you have a simple exchange of purchase orders, what typically happens is that first the buyer goes ahead and submits a purchase order that's got a bunch of unreasonable fine print on the back that's one-sided in their favor. And then what happens on the other side, the acceptance that comes back or the acknowledgement, instead attempts to substitute the seller's purchase order conditions that are probably just as unreasonable on the seller's side. Of course, a lot of this might be happening electronically and not with paper anymore, but that's the way that a lot of business operations work in a supply chain. Some of the same sort of thing, of course, happens when you have the big contracts, but the big contracts that then result in releases over time of things that are actually ordered, those tend to be negotiated, and at least you will have more of an opportunity to determine what your terms are. So when people send these purchase order forms back and forth, one of the things that becomes relevant for everyone to understand is what the heck actually happens. And to do this, I need to spend a minute or two on basic contract law. Contract law comes from two sources. One is common law, which is just the accumulation of cases on contracts over time. And the other one is the Uniform Commercial Code, which is a statute. Now, the Uniform Commercial Code focuses on goods, whereas if you have a service contract, that's normally governed by the common law of contracts. And one of the issues that happens here is that the two sets of law are slightly different. And whether they're slightly different is on the topic of how a contract forms, and when the contract forms, what are the relevant terms. There are really two rules that are relevant here under the common law of contracts. One is called the mirror image rule, which basically says that in order for there to be a contract, the offer and the acceptance have to be on the exactly identical thing. If it's not exactly identical, in other words, if somebody makes an offer and the other side says, I'll agree to that except that I want to get paid over 5 days, as opposed to paid after, then in those particular circumstances, that's actually a counteroffer. There's no contract by saying, yeah, I'll do that except I want to be paid later. The contract would be formed then if the other party came back and said, okay, yeah, I agree to that. So that's an important rule to understand, the mirror image rule in common law contracts. The second related thing is a thing called the last shot rule. The last shot rule basically says that when you have printed forms going back and forth, and those printed forms have terms and conditions, the last printed form that is exchanged before performance is a set of rules that will govern, a set of terms that will govern. Well, performance, for example, can be a lot of things. One of the things that performance can be is paying the purchase price in advance. So if you've prepaid and the parties have gone back and forth and sent each other their terms on several occasions, the last party to send the term before the payment is made is the one that gets lucky and has those terms applied to the deal. Well, you can see that this might create situations of unfairness. So in the Uniform Commercial Code, that rule is modified. The big thing for all of you to understand at this point, without getting into huge detail about how that all works, is that under the Uniform Commercial Code, the odds are loaded very, very heavily in favor of a buyer. So whenever you're talking about the sale of goods between merchants, such as happens in a supply chain, you're talking about the Uniform Commercial Code, and generally speaking, if you're the seller, you will always be at a disadvantage in being able to introduce your terms through this exchange of documents and battle of the form. You will lose virtually every time. So for you, even though you might go crazy wanting to negotiate one of those big contracts, it actually makes more sense overall for you to be in that contract negotiation, because you almost invariably lose a simple exchange of purchase orders. So that's what we refer to when we talk about the battle of forms. Now, when we talk about these various different forms of the law, it becomes important to distinguish between the sale of goods and services, because a lot of people might actually sell some of both. There might be, for example, some design companies that design a product, and what they'll do is sell the design and get paid for the design services, but they may also later manufacture the actual goods that they designed for the person who they did the work for. Well, once you start manufacturing the goods, then the UCC governs. And the way it works is that if the predominant part of a contract actually is for the sale of goods, then even the services part of the agreement is covered by the Uniform Commercial Code. So you can find circumstances where you're better off in your negotiations to have separate contracts for your services as opposed to the contracts that you enter into when you're selling goods. So now with that background, let's try and get more specific. And I'm picking an example here that you've been reading in the news about recently. You know, one of the most sophisticated supply chains that exists out there right now is the automotive supply chain. Just-in-time and lean manufacturing makes different suppliers in the various tiers of supply almost like part of one giant factory for the ultimate auto manufacturer. As you can see from this slide, in any one car, there could be as many as 20 to 30,000 individual parts that are supplied to make that car. So there are tiers of suppliers that make subcomponents, components that go into the subcomponents, and actually parts and raw materials. So let's get into a practical example. You know that GM recently has gotten into some really hot water because it recalled a number of products, cars, with Chevy Cobalt, for example, and the Pontiac GS and the Saturn Ion, and several others. And they were accused of delaying their recall of these cars, and that their delay caused several people to die in auto accidents. Well, let's talk about what in the end is the issue. The issue is something that relates to the ignition. And as you can see, the ignition assembly is part of the overall steering column. And the ignition assembly has a number of pieces, and the relevant piece that's at issue is the ignition switch, which you'll see is just one small part of the ignition. If you look at what's inside the ignition switch, the actual problem that has resulted in these accidents is with a very specific item called the détente plunger. The old version is the top version, the new version is the lower version. And what you have is a little less spring loading to keep the cylinder and the key in place. And that's what's made the difference with cars getting out of control and shifting into unauthorized modes while people were driving. So imagine that you're the supplier of this particular component. And in fact, one of the things that you want to imagine is exactly how you ended up getting the specifications and what you ended up agreeing to do and to be responsible for in designing this. Now, mind you, you probably are several layers down the supply chain. You probably got your drawings from someone who's a supplier to GM, and GM probably had their design drawings that they provided to that immediate supplier. You don't even know necessarily whether you're getting good information about exactly what this part is supposed to do, but you may be asked to sign a contract that has you certifying that you are responsible for the design of this detente plunger. Now, after that example on goods, let's just briefly talk about the services environment. First of all, the services environment includes plenty of manufacturers. As I mentioned before, a lot of manufacturers actually provide some design services. Those design services should always be kept in a separate contractual arrangement whenever possible and not made part of the underlying contract. And this can happen when you're prototyping new products, when you're doing custom design work, and what you're going to be doing is you're going to be hoping to actually do the supply contract. At the time you're doing this design work is the best time to negotiate the ultimate supply contract and not leave that till later. In other service industries, such as construction, IT services, consulting, and accounting services, there are key things that you ought to be thinking about in your contracts. Obviously, always, price and quantity are a big deal, but aside from those things, you really need to be thinking about what your actual deliverables are in a service contract and what your performance metrics are. And this is where most contract disputes actually come into play. People are having difficulty not with knowing how much they're supposed to be paid. There's a difficulty in being able to prove that you performed in a service contract what you were supposed to do. So, being specific enough, but leaving yourself flexibility on deliverables, and also being specific enough, but leaving some room for performance metrics is also a very critical thing on supply contracts. Okay, what we're going to do briefly is now talk a little bit about the psychology, and this is one of the things that drives how you go about negotiating with big companies. Most big companies will have an in-house legal department. Now, if you think about it from the in-house legal department lawyer's standpoint, what they have is a responsibility to try and limit the company's risks. And the way they do it in a big organization with lots of people is they create standard forms and they create standard procedures. When they create these standard forms and standard procedures, they really want to have a minimum amount of deviation. When they create these contracts, they know that the contracts are going to be, in some cases, inappropriate because they're trying to cover every situation possible. So, of course, from your standpoint, you might get one of these contracts and you might be massively annoyed by the whole concept that you've got a 60-page contract that you're asked to review and negotiate, and all you're doing is providing paper clips. Well, you need to figure out a way to understand what's important to that company and to the general counsel's forms and see how you can get around it. One thing is you have to understand that often the purchasing department, which has been handed these forms and procedures, is generally told that they shouldn't deviate from those forms. And the purchasing department is typically happy to do it. So one very, very early thing in any negotiation of a giant contract like that to do is to find out how you can actually get to the lawyer who has authority to negotiate it. Now, sometimes that authority is left in the purchasing department and you can do it that way. But why it's important is you don't want to be stuck with being unable to negotiate because the purchasing guy is telling you he can't make the change. So you have to figure out a way to get to that lawyer. And we find that once you actually get to those folks, we've had great success in actually being able to negotiate changes that sometimes the purchasing department is not even willing to consider. And that is another point here. The psychology of the purchasing department is key in doing this. You have to try and get them to be flexible. So now we're getting to the guts of how you go about actually doing this, and a lot of this is prep. The prep is listed in order of sequence right here in this slide. First of all, you need to really think about a checklist of what's most important to you. I know your first reaction is probably going to be, well, my price is the most important. But the fact of it is that is one of the few things that actually is negotiated accurately. You may not be happy with your result, but the things that actually are the most frustrating to negotiate are the things of the what ifs and what might happen. What's your liability for product's liability? Are you going to be required to supply spare parts for a number of years? Are you going to be in a position to guarantee that the exact coating of paint and shade that they wanted is something that you have to guarantee, or it's somebody else's responsibility? You often don't even know whether or not their incoming inspection will even inspect anything that you provide, and you don't know if a defect is only going to be found when the product has already been fully assembled and your part that's in the core center of it fails. So, keeping all those things in mind, you need to create a checklist of what's important for you. You got to prioritize them because your sales folks will need to understand this and understand what's important, because if you don't tell them this, the only thing they have to work with is the quantity, delivery dates, and purchase price, and you need to get them geared in to starting these issues at the first stages of negotiations. You need to be able to know what your desired outcome is in these contracts, and your own preferred forms and your terms and conditions should match those desired outcomes. Then you need to have some range of what's acceptable to you. Things that aren't exactly how you want them, but are okay, because that is going to set the parameter of how you negotiate each of those individual provisions. And then you prepare a list of negotiating options. Once you've done all this, you have to train your negotiators, which are often your salespeople. And many salespeople get no training in this. And finally, you need to understand what the customer really needs with their printed terms, because sometimes their printed terms are not necessarily reflective of what they really need, and it helps you negotiate. Now, to take what was a pretty abstract slide and try and be more specific about it, I'm going to give you an example of a prioritized checklist of items that actually several of our clients use, and I've changed the priorities a little bit here. Different companies have different priorities, but for example, in the white goods industry and in the auto distribution chain, these are very reflective of the things that the clients are very, very concerned about, because these are the kind of things that can, in the end, kill them. As you can see, this particular client is really concerned about making sure that the specs are the specs of the buyer. The buyer steps up and agrees at their specs, and they're only making it to their specs. That the actual seller is not the designer of the product. He wants to make sure that the warranty will only apply to the extent that they meet the specs. If they meet the specs and the product still doesn't work, that should be the buyer's problem, because the buyer was the designer. They want to make sure that if there's a breach of warranty, that only certain things happen. They can replace the parts, but nobody waits until there's this gigantic recall and billions of dollars of cost before advising them so that they can take action early. They want to specify what will happen if there's a product liability claim and how they're going to defend them. They want to know who's going to inspect the product when it comes in the door, or are they not going to inspect it at all, which has a big impact on what the cost is when you find a defect later. They want to know that if a plaintiff names them in a lawsuit, for example, in one of the GM lawsuits, that they will be defended by the auto manufacturer. And so on with the various terms. And you can see that this particular client has this order of priority. So it is now clear to the salesperson who otherwise has been told about price, quantity, and delivery terms, what other things that salesperson needs to raise early on with the purchasing department so that the first time that the issue comes up is not when they hand you their standard form and you're just reacting to their standard form. Because what you want to do is have some items negotiated in principle before you get the standard form, and where the standard form deviates, you can immediately point out that that wasn't your deal. If you wait till the standard form has been handed to you, they're going to perceive you're just reacting to that. So let's delve into what this looks like. So you got this checklist, and then what you do is you prepare with the checklist your idea of what you would like as an outcome from that. So, for example, you'll see this is the first one from the prior page, manufacturer to specs. So, this is what we want to do in the agreement. We want the agreement to say that the recommendations of the seller were independently approved and adopted by the customer. We want to be clear of what the heck the specs are. Lots of times people say that you have to conform with the specs, but they're no good in really clearly telling you what they are. We want to exclude intended use or purpose clauses. And we want to avoid incorporation of other documents. Lots of these agreements say we automatically incorporate the quality control procedure that we have, and you don't even see it. You may have to adopt it and fess up to that, but the fact of it is you don't want that to happen automatically. It's got to be part of your negotiation. Second example, again, from the earlier page. Now you'll see that what we do is we give guidance and say the warranty life is 12 months from delivery date, but we might have to agree to something as much as 18 to 24 months for the ultimate manufacturer's warranty. So we're prepared and we know what our parameters are to negotiate. What we have to be careful about are free from defects in materials or free of defects from design clauses, because we don't want to be the designer. If GM has told you what it's supposed to look like, you need to have them accept your design and take responsibility for it, because you really don't know all the other details of the car in which the part is to be incorporated. And you have to specifically say that there is no defect for contract purposes if in fact you met the specs. So now with that example in mind, or with that background in mind, I want to go back to the GM recall example, and I just want to show you what GM issued in some of its press releases about its findings after its long investigation. And I'm being a little sarcastic here, obviously, but guess what? You'll see the bolded parts. Ignition switches in early model Cobalts did not meet GM's torque specification. Remember that little detente spring that we had a couple slides back? That's what they're talking about. And continuing in the press release, changes were made in 2006 which increased the torque. That means the improved detente switch. And then later, whether the installed ignition switch meets the torque specifications provided to its supplier. You can see how GM is already trying to offload responsibility here. This, even though your price is really important, this, in light of this recall, is something that can kill your company, not just cause you to have a poor contract. All right, with all that background in mind, it's really important to help your sales folks out, both your direct sales folks and sales support. You really need to have a process where these key issues off this list are introduced to the company, the big company, when you first start talking about the contract. Because once you get them early in mind that these are important issues to you, you're going to lay the foundation and finally be able to actually take that 60-page contract, make changes without anybody being surprised that you're making them. Now, what you're going to do is you're not going to mess at all with the thousands of other things that are in that 60-page contract, because they're not as important as the things that you've already prioritized. Your entire focus in your negotiation and order of priority is to get the top things that are on that list and to get yourself in the parameters that you've already created for each of those factors in evaluating the contract. You'll see that based on this is that rather than viewing this as some kind of a super negotiator process where you somehow expect your salesman, who first of all, of course, wants to make a sale, but you expect your salesman to do some sort of magical negotiation that's not really realistic. Instead, you've provided a process for him to be able to bring back a contract that then you can make changes to. No one's surprised, and people know that that was part of the original core deal and not just you going in and marking up the 60-page contract. The worst thing you can do is get one of those contracts and start in line 1 and go through and mark everything. That, in fact, is a signal to the big company that all you're doing is just messing with their particular contract because you think that it's a matter of principle. Stick to the important things, focus your negotiations on that, and train your salespeople to bring those issues up early. Obviously, this sort of a seminar on negotiation can have hours and hours of additional pieces on specific negotiating techniques, and we may do that going forward. But right now, our primary focus is to get you started with the idea of how you go about doing this and provide a procedure for that rather than simply looking at a contract and saying to yourself, well, what the heck am I supposed to do with this? Hopefully you'll find this helpful. Thank you.